Roland Mumford, Mumford.law. I want to discuss with you about age discrimination claims. If you're employed and you want to file an age discrimination claim with the EEOC, you must be 40 years or older, and most federal court districts require that the comparator, the younger person that you would be compared against, must be between 6 to 8 years younger than you, and in some cases they may need to be even older. Now, there are about 3 average fact patterns that often involve age discrimination. The most common claim that I get is that a person over the age of 40 has been terminated and they've been replaced by somebody younger, obviously 6 to 8 years younger or older. Another type of claim would be where you're being discriminated on the basis of or arising out of your age. Now, there's this phrase or this term I often hear called ageist. In essence, somebody that discriminates against older people. And that would be maybe comments that are made in the workplace. Is there a disparate treatment in terms of how you are treated compared to younger people? Is there more favorable treatment based upon that protected class? I once represented 3 elderly people that were in their 70s and one was early 80s, and they worked for a very large retailer. And what we noticed was this particular retailer was trying to force out these older employees, and they would do all kinds of childish things. For example, we would find out that the younger employees, one was even a manager, they were allowed to take advantage of discounts of certain retail products, but yet when the older employees wanted to purchase the same items, if it was marked down on sale, they would always be paying the higher price. It was a very odd fact pattern, but we resolved that claim successfully. It's very difficult at times to prove the discriminatory intent of a person that is attempting to treat you worse than somebody younger. Now, a lot of times it might be where maybe it's a warehouse position or a factory, and they're trying to force out older employees because they know that the older employees are going to be more subject to maybe disability claims. It's more difficult for them to do things physically, and so they want to try to bring in some young blood. And there also have been cases that I've litigated where older employees were discriminated against on the basis of the wages. Older people were paid much less than younger people coming in with much less experience. So there's all kinds of fact patterns involved in age discrimination, but usually the typical fact pattern I see again is somebody that's terminated and replaced by somebody younger where they had much less experience. That's a key typical fact pattern. Or there's a disparate treatment in the basis of wages, benefits, or other forms of material terms and conditions and benefits of employment. I hope this information helps you. Remember, you must be 40 years or older under the Age Discrimination and Employment Act, and in most federal districts, they've got to be 6 to 8, 10 years younger than you or even older.